Believe it or not, one of the most important changes in American history occurred pretty early on in the administration of President Jefferson, but it was really started during the administration of President Adams. And we have it phrased here as the dead clutch of the judiciary. And it was actually an act of Congress that then led to the appointment of judges, which eventually led to the Supreme Court becoming a full fledged 100% equal member of government. And it's an interesting story to see how we got there, how we took something that is not technically in the Constitution. We do this a lot. And made it part of the Constitution in a way that the American people, have accepted this wholeheartedly, even though there's a question as to the constitutionality of it in certain respects. Okay. Now, you had something known as the Judiciary Act. Okay, this was passed by the Federalists in the last days when they were still, in control of Congress. Okay, this was in 1801. What they did is that they created a whole bunch of brand new federal judgeships. Now, to begin with, a federal judge, if you're ever offered that job, I highly recommend you take it. It is a fantastic job. Not only do you get to be a judge, but under the Constitution, they cannot lower your salary for any reason. So no matter what, you're not going to get your pay docked. Secondly, the only way you quit being a federal judge is one, you decide to resign. You decide I don't want to be a judge anymore and you quit. Then you're no longer a federal judge. Two, you die or you resign through natural causes, in other words. Third, you can be impeached and removed from office, and we will talk about that later on, but that is so rare as to barely be spoken of. Okay? So the Federalists wanted to create a whole bunch of judges. Now, the reason for this is the judges would have a lifetime tenure. They would never be fired. The Federalists had lost the presidency and they had lost the Congress. But they reasoned if they could go through and they could put a whole bunch of Federalist judges on the bench, then they would still have a great deal of authority. They would still have the ability to influence national policy. And remember, since judges like this serve for life, you can put somebody on the bench at, say, 38 years old or 40 years old, and they might be there. I mean, in today's standards, they could be there another 30 or 40 years. So they tried to basically create all these judgeships to fill them with loyal Federalists for the purpose of making sure that their legacy was going to survive into essentially eternity. Now, there is a gentleman. He was not the first Chief Justice of the United States. That went to John Jay. But probably the most influential Chief Justice that had the longest reach of anyone is a gentleman by the name of John Marshall. And here he is. Okay. Now, Chief Justice John Marshall, believe it or not, this guy was a cousin of Thomas Jefferson. Okay. He had served in the Continental Army. He had served at Valley Forge. And while he was there, the phrase is he had been impressed with the drawbacks of no central authority. Now, do not take the word impressed to mean like he thought it was great or anything. No, quite the opposite. It had left a very negative impression on him. He saw how bad things could be when there was no central authority, when there was no real solid government to back, the laws and the rules and everything like that. And as a result of his experience at Valley Forge, seeing the fact that the troops didn't get food and clothing and things like that, he became an ardent and lifelong Federalist. Okay, he was very, very dedicated to the concept of strengthening the power of the federal government. Okay, he went through, and he's going to be quite different from his cousin. Okay, he and President Jefferson are not going to see eye to eye on a great number of things. Now, being Chief Justice of the United States is really an amazing job that I can only imagine. You're running the Supreme Court. The decisions that you make and the rulings you hand down have long-lasting impacts. Now, we understand that today. But we understand that the Supreme Court has a great deal of power because of the man you see sitting there. John Marshall went through and he was able to transform the Supreme Court into a co-equal branch of government that today we as the American people look at the Supreme Court as the final arbiter of any question. The Supreme Court is the one who decides what is and is not constitutional. The Supreme Court makes that decision. Now, it wasn't exactly set up that way originally, but it was the actions of Chief Justice Marshall that changed everything. And when he made these changes, a great number of the framers of the Constitution were still alive, and they didn't voice a huge amount of concern or any kind of opposition. So the decisions he's about to make are going to have a long-lasting impact and influence all the way through from about 1803 until the very present day. Now, the case is called Marbury versus Madison. Now, in Marbury versus Madison, we had what are referred to as the Midnight Judges. Okay, these are the judges that the Federalists had created. That John Adams, the story is that he stayed up till midnight on the last night he was president, signing the orders making these people judges. So therefore, they were the Midnight Judges. Okay, they were appointed by John Adams in his last hour as president. And one of the guys, a gentleman by the name of William Marbury. Okay, William Marbury was a very staunch, very solid Federalist, and he was named Justice of the Peace for the District of Columbia. Again, this is a federal judgeship. This means that he is going to be there for life. He's going to have a long-standing impact on the government for, pretty much until he either chooses to retire or dies. And the result of all of this is, in the Federalist eyes, they will still have that influence. Okay, so he's been named Justice of the Peace. He leaves his home. He goes to Washington, D.C. because he's got this job. And many of us, if we're offered a federal judgeship, would take it right away. I personally would. If I get a call that tomorrow I am to be made a federal judge, I will gladly try and get you guys a substitute teacher because I shall not be there. But in this case, Mr. Marbury arrives and he wants his job. Now, the Secretary of State at this time is a gentleman by the name of James Madison. Now, James Madison is the father of the Constitution. He says no. He shelves the position. He says, no, we're not going to do that. So the guy's been given a job. It's been cleared and everything by the president and whatnot, and he shows up to basically, start working. And the Secretary of State says, no, we're not doing that. And he does what a great number of Americans would do in this situation. He goes to court. He sues for the delivery of his job. He wants to start being a judge. And it goes to all the way up to the Supreme Court. Now, the important thing about this is that for the first time, the Supreme Court has ruled something to be unconstitutional. The Supreme Court, Mr. Justice Marshall, the Chief Justice, he gets a choice. He can go through and he can either decide to do something that will benefit his political party, or he can do something that will benefit the court and therefore the nation. And he decides that he wants to benefit the nation more than his own political party. The court rules that the Judiciary Act of 1789 was unconstitutional. For the first time ever, the Supreme Court of the United States had ruled an act of Congress unconstitutional, that it had violated the Constitution itself. And under the Supremacy Clause, nothing can violate the Constitution. This had never been done before by the court. Today we know it as what's called judicial review. Today we understand that if there is a constitutional question, it will work its way through the system until such time as it arrives at the Supreme Court itself. The Supreme Court will then make a ruling as to whether or not the Constitution has been violated. Now today that applies to any action by the national government or the federal government, the state government, the county government, the city government or municipal government, school district, anything. All of those can be subject to constitutional interpretation. The Chief Justice made a ruling. He said that it was unconstitutional. And the framers of the Constitution who were still alive did not rise up in horror saying that you can't do that. Case was dismissed, but judicial review had been created. And we're still going to be looking at judicial review 200 years later. We're still talking about it. We're still going through and using it on a regular basis. We still accept the fact that even though it's not specifically listed in the Constitution, that it is one of the bedrock, cornerstone, foundational aspects of our Constitution. Judicial review had come into existence thanks to Chief Justice Marshall. Now, there are times within our government that the president and the other branches, well, they may not get along too well. And such was the case between President Jefferson and a member of the Supreme Court. Now, I did mention before that one of the few ways that you can be removed from being a federal judge, and that includes the Supreme Court, is through the process of impeachment. Now, most people hear impeachment and their first thought is the removal of the president from office. That's not the case. Impeachment merely means that an accusation has been made, and it's possible that that accusation may remove the person from office. But that's for the president, that's for essentially anyone in government. They do have that possibility of being impeached and removed from office. So in this case, it's 1804. President Jefferson decides that he's had enough with one of the Supreme Court justices, referred to as the tart-tongued Supreme Court Justice Samuel Chase. He brings charges. They get an article of impeachment against the justice. And the way an impeachment works is the House brings charges of impeachment, but then the Senate actually holds a trial. And it does require a supermajority to remove the individual from office, be that the president, vice president, justice of the Supreme Court, any of the above. So they do get articles of impeachment drawn up in the House. But when it goes to the Senate for a vote, there were not enough votes. Even though President Jefferson did not care for Justice Chase, his attempt to remove him from office through articles of impeachment failed. That was in 1804. 216 years later, no one has ever tried to impeach a justice of the Supreme Court again. We have gone through, and the argument, at least as far as I look at it, would be that we've chosen pretty well both presidents and Supreme Court justices in that we haven't had any impeached and removed. We've either had a very good run or a very lucky run. It depends on your particular outlook. But because of the failure to remove Justice Chase from the bench, no Supreme Court justice has ever faced impeachment ever again.